Okay, good evening. On behalf of the Stanford program in Law and Society, which is one of our very best programs, I must say, of all of the programs, it's one of the very best. How are you? It's my great pleasure to welcome you to this event with Professor Greg Shaffer, who is the Melvin Steen Professor of Law at the University of Minnesota Law School. Before that, Greg, I'm going to depart from convention. I'm going to refer to him by his first name because Greg and I actually were in law school together, although he was older and wiser then. And we have had many opportunities to interact through some of our professional activities. So he's a friend. Before his time at the University of Minnesota, Greg was on the faculty at the University of Wisconsin Law School, and before that at Loyola University Chicago School of Law. He teaches courses in international law, international trade law, European Union law, administrative law, and constitutional law, and conducts a variety of research seminars. His publications include, and this is a little embarrassing for me to say because each of these is a book, not merely an article or an op-ed. His publications include Dispute Settlement at the WTO, The Developing Country Experience with Ricardo Melendez-Ortiz, When Cooperation Fails, The International Law and Politics of Genetically Modified Foods with Mark Pollack, Defending Interests, Public-Private Partnerships in WTO Litigation, Transatlantic Governance and the Global Economy with Mark Pollack, and over 60 articles and book chapters on international trade law, global governance, and globalization's impact on domestic regulation. Greg is also on the Executive Council. Actually, he's now, as an official, can we say it? He's now the Vice President, or the Vice President-elect, a Vice President-elect, of the American Society of International Law. He's co-chair of ASIL's International Economic Law Group and a founding board member of the Society of International Economic Law. In addition to his kind of impressive academic achievements, Greg connects his scholarship to the real world, and he's been a speaker at multiple conferences organized by the WTO appellate body on the occasion of its 10th anniversary. Before beginning his academic career, Greg practiced law in Paris for 7 years, where he was a member of the Parisian bar. And he received his BA from Dartmouth, but managed to expiate that sin by earning his JD at Stanford Law School, where he graduated in 1988. So please join me in welcoming Greg to Stanford Law School. Oh, let me just say one thing. There will be total rookie mistake. Greg will be discussing his paper. Yes, page 2. Greg will be discussing his paper, How the WTO Shapes Regulatory Governance. And following his talk, we'll hear a comment from Professor William Simon, the Arthur Levitt Professor of Law at Columbia Law School, and our former colleague here at Stanford Law School. Thanks very much.
Great. Thank you, Alan. It's really great to be back here. Also, our daughter now is an undergraduate here, so this is wonderful. This is Parents' Weekend, so combining this is really terrific. This paper is an offshoot of what I'm doing in a couple books. Actually, one just came out this year called How Transnational Legal Process, Transnational Legal Ordering and State Change. And another book's coming out this year with Cambridge called Transnational Legal Orders. And what really interests me, which is sort of different than what a lot of international law literature does, is much of the international law literature is about global governance and sort of looking at relationships between states. And what really interests me is that what are the implications deep within nation states of what we see at the international level? And that's what this paper tries to do. We're using the WTO as a vehicle, but arguing that the World Trade Organization, as an international organization, has greater implications for regulatory governance than any other international organization. That would be the starting point. And I'm very involved with the Law and Society Association. Hope many of you come to the 50th anniversary in Minneapolis. And I'm interested in the law. I coordinate a collaborative research network on global governance and transnational governance, looking at what's happening empirically. So welcome any people who are interested in those sorts of questions to see if you'd like to be engaged. Most literature on the World Trade Organization, if you read a case book on the World Trade Organization, It's very much the WTO sort of looms above the nation state on a separate plane, that of international law. And if you look at most of law and economics, for example, which is the dominant approach to looking at the World Trade Organization, it'll speak of the WTO using the analogy of contract law. The WTO law it's a contract between nation states. And it'll speak in such terms as if a nation state violates its commitments, you can look at this in terms of an efficient breach with a liability rule and so forth. And that frame's useful for understanding some aspects of WTO law, but it also misses a lot. And the paper, what it tries to do is investigate how the WTO permeates the nation state in terms of regulatory governance, looking at empirical work we have to date and opening up questions for empirical study. The attempt also is to move beyond much of the literature is about compliance, which is usually measured by compliance with particular WTO disputes. Especially you see this in political science, and the idea is to look, that's a sort of second order question, right? You have a dispute and there's compliance, really looking at the deeper regulatory implications. So let me just give a couple of examples to get started. In terms of professionals, the WTO includes an agreement on intellectual property rights. So a question becomes, what broader changes do we see from this agreement? And just to give a couple of figures in terms of the rapid growth of intellectual property as a discipline in countries around the world, which basically, if you looked at the number of patent filings, right, and the amount of patent litigation in most developing countries pre-1995, or if you just looked into the curriculum of law schools, this didn't exist pre-1995 to most. So here's just a couple of figures. From 1997 to 2011, patent filings increased in Brazil by 106%, in India by 605%, and in China by 3,245%. Just from 2005, patent filings exploded from around 476,000 in China to 1.1 million in 2010. In 1995, for patent examinations, China had less than 400 patent examiners. Right? Today, it is expected to have next year around 10,000. And what's holding it back is it can't train enough people fast enough, right, for this booming explosion. So you see huge professional growth. And of course, when you see professional growth, you see professional stakes, right, which embed these legal norms in practice. Okay? That creates a huge amount of work, giving rise to new agencies, new law courses, new types of lawyers and other professional specialists. In other words, the WTO is about professional change in states and not just about legal change. Court cases are booming in emerging economies, especially on intellectual property, engaging judiciaries, affecting their relative roles in national governance. So the WTO's implications for what I call the architecture, the institutional architecture of states. In China, for example, litigation involving intellectual property rose in 2003 from 9,000 cases to in 2010, 42,000 cases. It's a lot of role for lawyers, a lot of role for courts. In India and Brazil, you see major litigation going up to their Supreme Courts involving patents and the right to health. You see litigation over the right to health in multiple developing countries and its relationship with intellectual property law. Russia recently joined the WTO, and as part of the WTO process, it created a new intellectual property court. So you see the creation of new institutions because of the number of WTO agreements that call for judicial review. And the empirical question is, how do these actually play out in practice? How to think about state sovereignty in the World Trade Organization. Tax lies at the heart of state sovereignty, and traditionally international law stays away from tax. There's no, indeed, the state's depends on raising revenue. The only international agreement that permits for litigation against another state about its tax system is the World Trade Organization. And actually, in terms of the total number of claims brought before the World Trade Organization, 10% of it, roughly 10%, are about tax law, including one of the biggest ever, which was brought by the European Union against the United States, where the European Union was authorized to withdraw trade concessions against the United States in the amount of $4 billion a year. That, of course, creates a lot of leverage to put pressure even on our Congress, and it did change tax legislation twice in light of these WTO complaints. And traditionally, as you know, our own Congress looks askance at the implications of international law. In other words, the WTO implicates the state's legal dimension, but more than that. It also implicates the state's resource dimension, how the state funds itself. And as we'll see, its welfare dimension, including market making and market correcting regulation, as well as its legitimacy function, going to the heart of democracy. So what I'll do is three things in this paper. One, I'll just start with the broader theoretical frames that are out there regarding law and globalization and state change. Then I'll speak briefly about WTO rules and the scope of what they cover. And then I'll address, which is the heart of the paper, what I call 4 dimensions of change in regulatory governance. And the 4 dimensions, I gave an inkling of them with the examples at the start, are 1, the boundary between the state and the market. What does the state do, and what does it leave for other forms of social ordering or for market ordering? The second is the institutional architecture of the state. What's the relative, and the key argument is going to be that you see the implication of the WTO is increased bureaucratization and an increased role for judiciaries. It'll be looking at the relative role of executives, of legislatures, agencies, and courts. Who has relative authority over what? Third dimension is this dimension of professional change, of professional stakes. What professions and technocrats are implicated by WTO rules? And the fourth will be the normative frame. How do we see what constitutes good regulation? Right? How does the World Trade Organization processes, and particularly what I call accountability mechanisms, shape this? What we typically think about WTO as a body of rules, right? And some disputes, right? Which made from time to time the New York Times. But the WTO, it's estimated, has about 5,000 meetings a year, bringing different government officials together. Right? They're sitting there debating, they're discussing, either defending themselves and also challenging the other. And they're all doing so within a particular normative frame. So the paper addresses that as a fourth important dimension for the regulatory governance. So in terms of theory, I'll try to go briefly here so I can get to the core of the paper. You see different theories which are more functionalist or culturalist or structural in terms of how to think about the implications for regulatory governance and shifts in international law. So a large culturalist one you see based on Stanford from John Meyer and others called world polity theory. Much of world polity theory talks about how states adapt to what they see as global cultural norms, which tend to be technocratic and legalized and come from the global north. But it also predicts significant decoupling between what you see at the local level and the national level and these global cultural frames because of the gaps between local cultural contexts and these global cultural rules. The traditional sort of law and economics view, of course, of the World Trade Organization is a functionalist one in terms of externalities of each other's regulations. The idea of solving a prisoner's dilemma, that if you reduce your tariffs and I reduce my tariffs, I might think that you might cheat, and so consequently you have this third-party dispute settlement system to ensure I won't cheat, to keep the deal, and we're all better off. The others that you'll see is I think important as a legal transplant theory. Much of WTO rules, if you really look at them, right, they didn't come out of nowhere, right? Much of them came, so you can take intellectual property rules, right? Most of these came out of the United States. And so you can see them as a form of globalized localisms, right? Local law that becomes globalized and then goes back into nation states. So you'll see, I'll talk a bit about the way protectionism is regulated by the WTO. And basically the WTO cabins the way you provide protection, stripping this power away from legislatures, which traditionally would use had control over the purse and would raise revenue through tariffs, right? And channels it into bureaucratized agencies subject to judicial review called anti-dumping law, countervailing duty law, and safeguard law, which is very technocratic and very legalized. And so, but this all comes out of U.S. law, right? It wasn't dreamt of at the international level. It's basically exported from the U.S. and then diffused around the world through the WTO. The other predictions of convergence in terms of social connectedness, especially through epistemic communities, so that you see problems socially constructed in common frames which are brought home. And the frame that I use with the sociologist Terry Halliday at the American Bar Foundation is try to look at to see where do these global norms come from, and how do they settle, and what explains variation in how they settle. And so this paper tries to provide a framework, at least to see where these norms, what are the implications of these norms deep within nation states in terms of practice. So the WTO requirements, there are 18 WTO agreements. There's actually 22,000 pages of text. Of jurisprudence, there's now 80,000 pages of jurisprudence. Have fun reading it. Clearly very technocratic, right? Requires scores of changes in national law. But just to sort of summarize in terms of what it touches upon, it shapes how states raise revenue. It shapes how states spend revenue. And it shapes the administrative principles for how states regulate. At its core, it's about the reduction of tariffs, often to zero. It's about norms of non-discrimination, depending on, of course, how discrimination is defined as a concept. In the process, it affects tax systems, industrial policy, standard setting, how you provide protection, and rules of administrative procedure. In terms of lowering taxes, just to give an example, of course, the predecessor of the WTO is the GATT, which comes out of 1948, created after World War II. At that time, when they started negotiating the GATT, 46% of U.S. revenue came from tariff and excise taxes. Okay. Today, it's around 3%. Okay. The tariff rates have been negotiated down through 8 rounds of negotiations. So the tariff revenue is a small part of U.S. tax revenue. But now think about this with developing countries. That was an easy way for developing countries to fund the state, right? An article comes in, customs officials take a percentage, right? And that goes into the national treasury. Now when they have to bind their tariffs, and you start talking about 50, 80% of tax revenue, maybe more of developing countries coming through customs, think of the broader institutional implications. Well, now they have to have tax reporting services. They have value-added taxes. They have income taxes. Suddenly you have tax specialists advising people how to pay those taxes and avoid having to pay those taxes. So you have new types of tax courses which are being taught. So it has major implications for tax systems, which are typically never talked about in the standard course, right, in the World Trade Organization. This can actually lead, there's documented where this has led to riots, because you think about it, you're in an African country and you lower your tariffs, you try to fund the state somehow, you raise sales taxes and you raise them on food, and suddenly the cost of bread goes up, right? That makes people very upset, and there are documented cases where they tried to implement these tax systems. There's been huge resistance, as you can imagine. Think about how the state spends its money. The heart of the developmental state is about industrial policy, building infant industries, which requires subsidization, typically involves tax holidays or tax deferrals and so forth. Right? WTO limits the ability to subsidize, creates rules on subsidization, which are often used through tax. Right? So this strikes at the heart of industrial policy, right? And choices of how states try to develop. Think about regulation, administrative principles for regulation. The two key principles in the WTO are one, non-discrimination. I think we're all, certainly for non-discrimination. But what does non-discrimination mean? And of course, this is subject to contestation over time. I wrote a book, as Alan mentioned, on genetically modified foods. Well, what do you compare for discrimination? Do you compare a non-genetically modified food with genetically modified food? Or do you only compare a genetically modified food with another genetically modified food? The standard understanding was you compare all soybeans, whether they're genetically modified, and if you don't permit in a genetically modified one, or you have stricter regulation, that constitutes discrimination. Or the major issue today for climate change. What if you were to have different policies for goods which are produced with carbon-intensive processes, carbon emission-intensive processes versus those which are not? Is that discrimination? So these sort of principles, are central for policy. Another policy principle is the least trade restrictive alternative. Choosing a regulatory alternative is not more trade restrictive than necessary. Well, what does that mean? Right? How closely does that cabin what a state can do, how it regulates? My own view is, and what I try to show in my work, is that actually the WTO in this area has really backed off. Right? And it's backed off because of a lot of pressure on not to push too far on states. Other people may disagree, but my point is that it's how the rules are interpreted as a contest involving multiple public and private actors. And of course, if any country, and there's a lot of my work, wants to play, it better develop legal capacity in order to try to shape these rules in terms of their meaning over time. The WTO involves harmonized national standards. Intellectual property is a clear example, but also that includes two agreements called the Sanitary and Phytosanitary Agreement involving all health measures, and Agreement on Technical Barriers to Trade. What this does is it creates a safe harbor for countries' regulation if they meet international standards. Now, what this has actually done in practice, and I think it'd be fascinating to show more empirically, is that many developing countries would have no standards before. So that we can have standard-setting bodies. And there's been a huge movement which actually enhanced regulation in many countries around the world to apply international standards. So you see sort of this harmonization process taking place. Well, harmonized import relief I talked about. And for the administrative state, I'm thinking of doing a project with a political scientist, there are all sorts of publicity, transparency, due process requirements written throughout WTO agreements, which can have, the question is how do these play out on the ground in different countries. So in terms of these dimensions of regulatory change and the shift of the boundary of the market and the state, my core argument is that the WTO is not just about neoliberalism and about deregulation. Clearly, market liberalization is central to its implications, but it also spurs increased public and private regulation. So the result is best seen as a shift in the boundary of the market and the state. In terms of the liberalizing force of the WTO, it represents an institutionalization that facilitates global product competition. It harnesses both external and internal pressure from public-private actors. It has a certain tilt toward market liberalization because you can only challenge regulation as a trade barrier. You can't challenge a regulation as being insufficiently protective of environmental, consumer, or other interests. And states challenge other states, even without bringing a formal legal complaint. So when Obama, during the Great Recession, the signature legislation of the Obama administration was the Buy America Act, and Canada and other countries complained about its provisions. And before it adopted by Congress, Congress changed the language to comply with WTO rules. Actors within states use the WTO as leverage to accomplish change that they would want anyway, but they find politically difficult. So I've got a lot of empirical work on India. India traditionally had what was called the license Raj. Everything had to go through a very complex licensing system, which involved a lot of corruption. And there was a push to try to end this, but very difficult. Change is difficult to accomplish in India. And the pressure from the WTO and a WTO case and these WTO committee meetings provided the leverage where they changed it, right? And then they triumphantly called this, the new India, right? Sort of opening up India as a new participant in law globalization. The conclusion that the WTO is only a force of deregulation is wrong. It can increase the size of the regulatory state in different ways. So here's a bunch of them. One, it calls for the creation of new agencies. Intellectual property, you see beautiful new buildings growing up in countries around the world funded by patent filings and so forth, where agencies it didn't exist before. You used to go in and be at some second story of some rickety house, right? You went to the old intellectual property agencies that existed before. Standard setting bodies. You see the growth of these different standard setting bodies in different countries. Second, the decrease in tariffs and the increase in trade raises concerns about consumer and other protection. And it creates pressure for increased health and safety regulation. And you can do it in different ways. So the U.S., excuse me, probably my wife prepared this weekend. Let me turn this up. So, sorry about that. It's the first time that happened to me. I had to keep this on because of this. In terms of, you see a lot of pressure, and the U.S., for example, has empowered private importers under regulation in terms of their new regulations in terms of imports from around the world. And so you get to see how these sort of diffuse effects on regulation in developing countries. The WTO provides also, as I've written, a shield as well as a sword. We often think of it only in terms of the sword of bringing claims against other countries. But so long as you comply with the EU has had major implications on U.S. regulation because the U.S. is constrained of how it can threaten to retaliate against Europe. So the first paper I did in academia was on enhancement of privacy regulation in Europe. And Europe has much more stringent privacy regulation than the U.S. in terms of how corporations treat private information. And looked at what sort of implications this had for companies that work both in Europe and in the United States. Another example is Europe has much more stringent chemicals regulation than the United States. And you see this having an impact on any company that wants to sell chemicals globally has to look at EU regulation. And the U.S. there's nothing it can do. If the U.S. to retaliate against Europe, Europe would have a claim against the U.S. under the WTO. The wealthy countries provide technical assistance to developing countries to enhance their regulation in order to protect their consumers. So to give an example, in the Great Lakes region of Africa, they were using cyanide to kill fish, right, in order to send it to Europe. Well, this wasn't something that Europeans necessarily wanted to eat, and it wasn't very good for the local fish or the local inhabitants. Right? And Europe provided technical assistance in order to try to change these practices on the ground. Right? And so you see sort of an increase in regulation in different countries where this regulation wouldn't exist without international trade. The WTO can spur private regulation. And so you see regulation outsourced to the private sector for timber, cut flowers, textiles, coffee, tea, fruits, and vegetables. And the paper goes into this, but it looks at private regulation not purely as an alternative, but rather as a complement to public regulation, because you often see public regulation and working hand in hand. And there's some interesting empirical work, for instance, on sustainable logging, which looks at the interaction between private regulation and what's happening on the ground in different developing countries. And then the WTO engages processes of justification. If you want to defend a regulation, you have to give some sort of regulatory justification besides protectionism. And I give some examples. One example in Brazil, it was limiting the import of retreaded tires from Europe. And it did so on environmental grounds. Well, to bolster that, and after this case, which Brazil won in terms of the environmental justification, Brazil engaged in all sorts of new regulatory activity to protect, so to have longer lasting tires and to create manufacturer liability and so forth. So by having to justify their regulation on non-protectionist grounds, it gave ammunition for activists, in this case environmental activists, to try to push for their own domestic regulation. In China, it has this case which is going to be before the appellate body this spring called the rare earths case. There are these rare earths which are used in very high value-added computer and high-tech products that is mined from China. And China was limiting the exports of these to have a competitive advantage for Chinese products. China's argument for doing so, it couldn't do so simply for protectionist reasons to give an advantage to its producers, so it argued environmental protection. Of course, we know that the environment is not in such great condition in China, but they had government white papers about this, and they've created all sorts of environmental initiatives with respect to mining and environmental protection and protection of rivers and so forth, which clearly states are not unitary actors, and there are those who are pushing for greater environmental regulation in China, and this is an example. In terms of shaping the architecture of the state, there's a lot been written on, and it's true that the WTO sort of enhances the power at the federal level of federalist states like India, like China, like the US, but you see sub-state entities also investing in expertise. I'm going to China this summer, and I'll have to go not just to Beijing, but to Shanghai and other cities to sort of see how they've created think tanks and so forth for their regional regulation, as well as to support their regional exports. You see executives becoming empowered. Executives are, in the sense, when I went to Europe and to Brussels, and I was interviewing member state representatives in the European context, they referred to the European Commission as the professor, because it had the knowledge, right, of WTO, this technocratic area which they did not have. You see the empowerment of agencies. As I talked about in protectionism, it used to be that legislatures could, at discretion, how to provide this. And in developmental states, the executive could simply decide when to grant a license, when not to grant a license, who would have the right context to grant a license. They've created now these sort of very legalized sort of requirements to provide for anti-dumping and countervailing duties, which has created, sort of empowered these type of agencies, but certain technocrats within them. And courts, the conventional literature on the way we think about national courts in the WTO, especially in the United States and Europe, is that WTO law has no direct effect, so no private person has standing before a U.S. court to bring a case or to raise the WTO as a legal issue. But the WTO calls for judicial review throughout its agreements. And you see increased activity of courts in many different countries, especially on intellectual property and in import relief. And it's going to vary, and it'll vary in very interesting ways. So, for example, there's empirical work showing on import relief that India, which is in technocratic international law terms a dualist country, which means that there's supposed to be complete separation between international law and national law. National courts refer to WTO law on import relief all the time. They read these cases, right, and apply them. Whereas a number of monist countries, like Brazil, supposedly there's not much court action, right? So you'd have to really go in to try to see how this plays out on the ground. In terms of catalyzing new professions, we saw this in the IP area, just in terms of the import relief laws. In terms of developing country investigations, this didn't exist prior to 1995. In 2009, not in terms of investigations, but actual anti-dumping awards, there were 1,600 covered, right? India, there was alone 668. Argentina, actually the 1600's got to be wrong, because in India there's been, I guess it's cumulative, right? Cumulative over like the last dozen years, India there's been 668 investigations, Argentina 353 investigations, Brazil 340 investigations. Professionally, there's whole new professions, right, which have arisen as of this. And if you think about those who come from a trade liberal perspective, and you say the Cato Institute, which is always sort of a big attacker of anti-dumping laws as a form of legalized protectionism, you've now created professional stakes in these countries around the world. It's going to be very difficult to get rid of this in India, right? Now that you got lawyers on both sides, right? And this hundreds of cases every year. So, and trade law also has grown in status in developing countries. So it's fascinating when I went to India and I would interview people in the trade bureaucracy. India has a very elite service, administrative service, where the top sort of 0.001% of those who take the service exam actually get into the service. In Brazil, many countries have this. So these are very elite members of society. Right? It used to be, who would want to do trade law work, right, in the past? Right? But now when I would interview these people, this would be the top post that they would be applying for. Right? And so this rises within status within different countries. And these people, their careers, the typical sort of civil service in these countries, they circulate. And they also have interagency meetings, right? Increasingly, because of the World Trade Organization, there's many more interagency type meetings than there used to be. So you see the norms can be diffused through professionals, civil service professionals, across agencies. And then finally, the normative frame and accountability mechanisms. Normative frames shape the way we perceive problems and shape the way we perceive solutions. But the frames are not simply given as in some Foucaultian analysis, that there's sort of a frame and we all behave procedurally. Rather, the WTO is much more, not really a free trade organization. If you go there and you talk to the diplomats, they're mercantilists. Right? They're defending their exports, right? And they're defending their domestic producers, right? So but the point of that is that opens up a space for contestation, because they have to justify their own regulations, and when they're challenging someone else's regulation, they got to look at what they themselves are doing. And that opens up a space for deliberation about how you interpret these rules over time, which is something which is, I think, lost in much of the literature on the World Trade Organization. So I talked about, what does non-discrimination mean? What is another basic principle for all health regulation is it has to undergo, under the WTO agreements, a scientific risk assessment. Well, what's a scientific risk assessment? Right? This has radically changed government bureaucracies, where you have now a procedural step of justifying regulation in scientific terms. Well, who does that empower within nation states, right? Certainly not legislatures alone, right? It empowers a form of those who have some knowledge of science, who have to justify the regulation in certain terms. And as I mentioned, the routine part of WTO is not dispute settlement. It's peer review, committee meetings. There are over 70 different types of committees in the WTO that meet. They have thousands of meetings every year. And they bring in, of course, the larger countries are able to fly in people from different agencies and participate to a much greater extent than developing countries. But as countries develop, and as they grow, their trade grows in importance, they become more engaged. And you see China, India, Brazil, each of which I've written on, highly engaged in this process. And this is perhaps sort of the understudied, hidden area where maybe the WTO has its greatest effect. So what I hope to do with this paper is, one, see the WTO in a different lens than the way it's traditionally viewed, And also, if anyone is interested in ever doing empirical work in this area in different countries, I would welcome to see you. Thank you very much. Okay,
we'll go ahead and
I'll end with one quick quote, two quick quotes. Oliver Wendell Holmes, I can't remember the quote, but this is from this book I'm coming out with, talked about law in terms of the history of a nation's development. And part of what I'm trying to say is that you can't think about law anyway in just those terms. Right? And when I recently gave a paper in the WTO in Denmark, I happened to be walking around the old town, walked past the temple of the courthouse with an inscription over the courthouse which said, "With law we shall construct the land." Well, where does this law come from?
So I'm going to say a few words about how the international trade regime influences or relates to ideals about democracy. So this is a theme that kind of swims through Greg's paper, sometimes above the surface, mostly below the surface. But all four of Greg's dimensions of change have some relationship to traditional notions of democracy, and the changes are often thought to be in tension in various ways with traditional notions of democracy. So it's a familiar claim that the WTO and the international trade regime is undermining democracy. I think, to the extent that that you can find evidence on the matter in Greg's paper, and I think you can find a lot, the story turns out to be much more complicated than that. So Greg's first category of change is the change in the boundary between the state and the market. And the conventional idea here is that the constriction of regulatory options for the state under the international trade regime undermines self-government, undermines democracy. And I think there are two qualifications here that we need to acknowledge. First, to the extent that the loss in autonomy comes from increased accountability for the external effects of a nation's activities on outsiders, we ought not to count that as a loss for democracy. Right? Democracy means self-government, not the ability to control the conduct of outsiders. And it's a pertinent fact to the assessment of traditional ideas of democracy that most of the countries that are conventionally thought to have the most secure and estimable democratic lineages are or were imperial powers, and democracy operated internally, not externally. So to the extent that we find that national autonomy is constrained by the international trade regime because of an increased demand for accountability for the external effects of conduct, that ought not to count as a problem in itself, or a problem for democracy. And then second, and this is of course the point that Greg emphasizes and elaborates very helpfully in the paper, the effect of the international trade regime is not consistently deregulatory. That is, the international trade regime actually induces national regulation, as Greg elaborates. And some of the procedural norms that are imposed on national regulation by the WTO are at least potentially democracy enhancing within the nation state. So countries that want to justify import restricting regulations often must show that they're supported by rational bases, frequently scientific bases, and such support often requires transparent processes of rulemaking and review of rules that may potentially enhance democratic accountability within the state as well as outside the state. Countries that want to export are sometimes required to show that their products are produced in accordance with processes that give stakeholders a role that they might not otherwise have. So for example, the EU regulation on forest law enforcement requires that legal compliance be monitored within exporting companies by stakeholders, at least by institutions that are open to stakeholders. On the other hand, if we turn from process requirements to substantive requirements, as the paper makes clear, we have to note that trade regimes more or less categorically take certain options off the table in ways that, you know, we want to understand as restricting self-government as well as imposing accountability. So as I understand it, the WTO makes it very difficult for developing countries to adopt industrial policies of the kind that Taiwan and South Korea used very successfully, or IP policies, or maybe anti-IP policies of the sort that India used to develop its drug industry before it joined the WTO. So Greg's second category of changes has to do with shifts in authority within the nation state, away from legislators toward executives and judiciaries and quasi-judicial agencies. Now, if we view the majoritarian legislature as the paradigmatically democratic branch, then this seems kind of problematical. But again, there are a couple of qualifications here. First, from a democratic point of view, from the point of view of the traditional ideal of democracy, majoritarian legislatures have some well-known defects. And two of those are, first, the danger of minority oppression, and second, the logic of collective action, right? The danger that concentrated interests will oppress diffuse interests. Now, just as human rights regimes potentially mitigate the first danger, the danger of minority oppression, international trade regimes potentially mitigate the second danger, the danger that comes from the logic of collective action. So to the extent that we think that protectionist legislation has a tendency to involve rent-seeking by special interest groups, the fact that they are made more difficult by the WTO is not necessarily bad for democracy. Second point, the changing role of the legislature that Greg describes in the international trade regime is arguably part of a broader trend that is not unique to the area of international trade, and in fact is not, would be with us even without the international trade regime. So generally we see a trend in many countries away from specifically directive legislation toward what in the EU is called framework legislation. So increasingly statutes, instead of specifying conduct, precisely instead specify procedures and parameters for the engagement of problems on an ongoing basis by administrators and stakeholders. That's a general phenomenon, not unique to international trade, and it seems to arise from the fact that the circumstances, the policy circumstances that the legislators are addressing involve increasingly a degree of volatility and diversity that makes stable categorical legislation inappropriate, right? So policy interventions have to be adaptable. They have to be able to contextualize in ways that traditional legislation, the conventional idea of legislation that we see in traditional democratic theory, inapposite. So the third category of change is the increased role for expertise as well as the change for expertise. So under the international trade regime, countries increasingly have a role to justify their their regulations to the extent that they have trade restrictive effects. This typically means that they have to have some type of rational basis, often a scientific basis, and this means that there have to be experts. Expertise is by definition elitist, so there is some tension here with traditional democracy. I just want to mention two aspects that might bear, however, on our assessment of how serious the challenge that the increased role of expertise in this regime presents for democracy. First of all, expertise is becoming increasingly interdisciplinary. The typical unit that responds to policy problems, at least sophisticated policy problems in the international arena and in the national arena as well, is the multidisciplinary team. So there are many problems for which no single discipline can claim ownership. And to this extent, they're very hard for the practitioners in a discipline to, there's a check on the ability of practitioners in a discipline to claim unchallenged authority. And it may be that there's a kind of checking function that goes from the fact that there are multiple disciplines involved. Secondly, in many professions, there's a change in the conception of expertise that sees it as more, sees expert judgment and the process of forming expert judgment as more explicit, more articulated, and more contestable in the past. So in the New Deal era, there was an idea, and not vanished at all in many areas of the professions, that the expert opinion was something ineffable and inarticulate, right? So we looked at the qualifications of the expert, but if the qualifications weren't adequate, we couldn't say too much about the substance. At least nobody outside the discipline could say too much about the substance of discipline. I think the disciplines see themselves less and less in that way. And more there's a notion people are trained, in fact, to present information that is designed to facilitate choice rather than to preempt choice. So to take, maybe not the best example, but nevertheless one that is a local one, law schools and medical schools teach counseling now, which they didn't do in the past. Not as much as they should, I can see. But the idea here is, there's a conception of expertise here that is, does not involve the preemption of judgment, but involves the facilitation of judgment. And we have, a very elaborate process. Jim Fishkin in the political science department runs these deliberative polling projects that some of you may be familiar with, that have very elaborate procedures in which more or less randomly selected samples of citizens deliberate on policy questions after experts have made a presentation to them. And the protocol for the experts in making this presentation involved one that is very respectful of the democratic choices of the citizen representatives that are supposed to be. And there's a professional discipline involved in the formulation of advice that does not preempt choice, that seems to be taking root in, or at least of interest, become a subject of interest in many professions. Okay, and then the fourth and the last of Greg's categories is normative frames. So there's a kind of a shift to the extent that political and legal discourse is influenced by the international trade regime. It's subject to pressures to emphasize more norms of deliberative engagement. And we see this in WTO law in the form, first of all, direct requirements of deliberation, requirements of reason giving and rational explanation and justification, and in norms of proportionality and less restrictive alternative. So these are all kind of the constituent norms of a very recognizable process of deliberative engagement. Now, the benign interpretation of this development, I don't mean to say the obviously correct interpretation, but a possible interpretation of this, this shift in normative frames is that it involves the emergence of a conception of transnational democracy. So one that's in tension with the traditional nation-state focused conception of democracy, one that departs from its major premises, but one that introduces the possibility of plausibly democratic ideals and practices in the international form. So the three features I have in mind of the traditional notion of democracy that are dispensed with here are first, territoriality. So the democracy in classical democratic theory is about the nation-state, and the nation-state is territorially defined, or perhaps a little bit by consanguinity, but mostly by territory. Its lawmaking is legitimated by the will of the electorate, right? the will of the electorate is critical to the legitimation of the lawmaking, and will implies a measure of non-accountability, right? So the electorate, the legislature is subject to constitutional constraints, but within those constraints, it's we dispense with any duty to justify what you do in the way that the WTO demands justification. So we don't talk about the will of a WTO member when we're talking about legislation, which we do in traditional democratic theory, we do talk about. And then thirdly, the separation of lawmaking from law enforcement. So lawmaking is the signature democratic process. Law enforcement has to be relatively mechanical or passive because it's not democratic. So to preserve the democratic legitimacy of the lawmaking process, we have to have automatic enforcement. Now, the vision that we see, I think, in these normative themes of the international trade regime, which we also see domestically in some spheres, is opposed on each of the three counts. First of all, publics no longer defined territorially, but defined in terms of common circumstances, in terms of shared relationship to a practical problem. Second of all, law emerges not from the will of a legislature, but from deliberative engagement, right? Deliberative connoting reasoning. And finally, law gets re-elaborated in the course of enforcement, right? Because of the need to adapt and contextualize, law can't be passively or mechanically enforced. That means it can't rely on a separate, segregated process of lawmaking for its democratic legitimacy. It means that the process of enforcement and elaboration has to have some democratic qualities. On the other hand, that fact lessens the burden of democratic justification on the original lawmaking process. Now, as I say, this is the optimistic, this is the upbeat interpretation of what goes on, and there's plenty of evidence both in Greg's paper and outside of Greg's paper for a much less, happy story about what's going on, in which, international trade law becomes the mechanism by which the rich nations exploit the poor nations, and by which capital exploits labor within the nation state. Don't mean to dismiss those stories at all, but I think that one of the many virtues of this paper is that it makes it very hard for us to adopt either of the simple stories, and suggests that the answer to the question of the relationship between democracy and these developments is going to be a complex one.
That's great. So Greg, why don't you go ahead and take the podium? Sure. If you have some responses to that, and then if you don't mind keeping your cue, or would you rather have me keep your cue, or just it's a small group and you can just take questions.
I kept the cue before. So thanks, Bill. That's terrific. If you want to write this, I'll join you. But it's really because part of what you did was, I think you gave took what the paper tries to do is try to show that it's a very complex way to try to address the WTO. Clearly, the WTO has major implications, right? Clearly, how the implications of the WTO depend on who participates within the system, right, and how it's shaped. And part of what my response to what you just sort of gave, sort of a way to see the WTO would be also a way to try to shape the WTO through that. This is to recontextualize it, as opposed to what I didn't say, which is if you look at a WTO casebook, it's a two-step process, right? The first step is you always start teaching trade law by theory of comparative advantage and why we're all better off with free trade. And then the second step is always why you need the WTO is because of basically public choice theory, that there are always going to be particular interests who will otherwise win out, and so you need to discipline democracy, right? In order to, and you need, the WTO does that. And that's the stand, you see that in every case, right? I need to write one, but I got other things I'm trying to write. But part of this is trying to tell us that this is a different story, that there's a positive aspect as, potential, clearly potential negative ones, and this is open for ongoing contestation, right? And so a lot of my work has been trying to see how different stakeholders build capacity in order to participate and shape it in ways that I find normatively desirable. Yes, okay. Anybody else? Alan?
Well, I should yield actually the first question to.
Sergio, go ahead.
No, well, I have prepared 4 questions, but I think 2 of them have been addressed before. So the first one is you locate the change in 1995, and I will argue why 1995 is what is different at the World Trade Organization that's not in NAFTA or other trade pacts. And I think the way that Professor Simon was putting it is the international trade regime in a more broadly. So could you elaborate a little bit more on what makes the World Trade Organization special? So the second, it's a little bit related to this, whether you see a way of affecting regulatory governance indirectly, right? The way in which World Trade Organization practices, rules, and mechanisms are incorporated into regional trade agreements that are becoming increasingly important. We are under there's the 2 mega deals that are being negotiated, the International Trans-Pacific Trade Partnership and the Transatlantic Trade Agreement. So to what extent there's an incorporation of these practices through other regional institutions, forcing the same aspect that you locate in the World Trade Organization through these different international organizations. And I think the third one that I have is how can we operationalize the analysis through the dispute settlement process? And I think what your paper wants to do is detach this from the traditional analysis of compliance and the enforcement side. But I think some of this will be good to see empirically through the dispute settlement process. And I was thinking it's like the changing nature of the regulatory regimes that have been challenged and the increasing number of private efforts that are now challenged to the World Trade Organization. The labeling requirements, or in the tuna case that Mexico brought against the U.S., for instance. The changing training of the lawyers who represent, the countries before the WTO. Where are they being trained now? What type of expertise they bring with? Or the changing use of the discourse, right? The normative discourse that they use. Instead of the early cases, my sense is there was a lot of defensive side from the South, right? Or the states that are resisting a little bit this, or trying to contest in this defensive way. Now they are also protecting their export markets. I think Álvaro Santos has written a little bit on the role of Brazil in this way. So these are the 3 long questions. Sorry.
Maybe since there are 3, I'll answer those first before I go to some more. So 1995. That would be misleading if I were to say that 1995 is always the key date. It's a key date for certain issues, but not necessarily for others. So clearly, as I tried to say, the WTO goes back to 1940. I mean, the GATT was an institutional predecessor, and that goes back to 1948. And actually, I've tried to do some recent empirical work on the GATT, because the original GATT is an international treaty. But actually, many of the provisions of the GATT come in 1934. The United States signed the Reciprocal Trade Act, which was when Congress granted very important and constitutional administrative law in the U.S. because Congress delegated authority to the administration to reduce tariffs by 50%, provided other countries did reciprocally. And this was challenged in a series of Supreme Court cases as, under the non-delegation doctrine. And And the Supreme Court said Congress can do this. But those agreements that the U.S. signed, it signed, most of those countries became members of the original GATT. And if you read the text of the model bilateral agreement, much of that text showed up in the GATT, right? Which now is a core of the WTO. So you see these processes in terms of an international trade regime through time. 1995 is an important date because of the TRIPS agreement and the intellectual property in particular. And so there you really can see a major shift that took time because there were transition periods that applied. And of course, law in the books doesn't necessarily take, but if it does take, there's going to be some time delay, including because of professions getting engaged and so forth there. And in the import regimes, developing countries had, even though they were members of the GATT, they hadn't actually bound their tariffs until the WTO. And so you see a huge increase in bound tariffs and reduction of tariff rates in developing countries. And of course, once you bind your tariffs, there's still going to be demand for protection. And since the WTO has cabined protection into 3 forms of administrative regulation, that you see the growth of these administrative bureaucracies in developing countries after 1995. So it depends in terms of what legal changes and institutional changes we're talking about. The indirect, it's interesting in terms of, and some, I think it's mischaracterized, but many will argue that sort of the WTO is looking for its identity today, because if you sort of read what the United States and the Obama administration is trying to do, it's trying to sign new acronyms, right? The TTIP, the Transatlantic Trade and Investment Partnership with Europe, and the TPP, the Trans-Pacific Partnership Agreement with Asian countries other than China. And geopolitically, this is viewed as sort of creating a circle around China, right, of U.S. influence. What you asked, which I think is interesting, is that if you actually did, what these agreements do is they do take core provisions of the WTO and put them in regional agreements. So it is going to frame, right, sort of the architecture of these agreements. Of course, the agreements try to go much further. We'll see how far they go. I am skeptical that we're going to see some of these agreements come to fruition, at least in some of the ways that they're talked about. They talk about putting environmental and labor provisions, enhanced intellectual property protection. They actually go much more to the core of regulatory governance. So it's all about regulatory cooperation, whatever that means. But for the United States, that means the Administrative Procedure Act and cost-benefit analysis, including for all legislation that comes out of Europe, and that's not a non-starter. Just like the U.S. Congress is not going to subject itself to cost-benefit analysis before it passes any statute. So we'll see how this all plays out. But what you said is sort of the indirect effect on these regional governance mechanisms. I haven't seen anybody do that, so that would be really interesting to see. I mean, clearly path dependencies can be viewed in terms of you don't start institutions from scratch. They are layered, right? They build on what comes before. And that clearly must be the case with what we're seeing in these new endeavors. How, the third question we can talk more about, but how operationalize analysis of the dispute settlement process. This article is going to show up in 2 places. One is as a book chapter in sort of transnational regulation, regulatory governance, but the other is for regulation and governance, a peer review journal. And there, I was told I gave too many examples, right, of dispute settlement, which sort of then goes against sort of the idea of trying to look at different forms of compliance besides dispute settlement compliance. But my contention is you need to show both, right? The cases do matter, the enforcement regime does matter, and the norms are interpreted over time and evolve over time. And dispute settlement is central to that. So I see it within a broader context. But I do try, and you can tell me how I should do it more, about seeing how the dispute settlement actually plays out in practice it's one of the most interesting questions, which is very few people have really addressed, is what are the real impacts on the ground of this litigation. And the most interesting work I've seen is actually by an economist, but one who took my trade law class at Wisconsin, who has checked 3 years after a case, have imports increased, right, which is the key question, as opposed to, well, sure, you complied, but nothing really changed. And he found that they significantly have. Right? And he has now a new draft paper updating that. We can talk about it. Yeah.
So love the paper, love the comment. Really both fantastic. Let me say just a word about the paper, why I love it. I mean, it's just so refreshing to see this kind of thoughtful capture of the kind of, well, we're here in the Law and Society program. So the Law and Society vision of the kind of the complexity of the way national systems interact with international rules and with an international regulatory regime. I mean, I have to say, I also sort of do some interdisciplinary work, and I hang out with political scientists, and I'm always looking, you know, for a little bit of evidence to basically kind of show that, you know, the law is not just a piece of paper, and it's not simply the case that states do whatever they were going to do, you know, in their interest anyway. You know, I was struck by the title of the paper, How the WTO Regulates Governance, and I was thinking about that, and the one question I had, maybe it's the next project, first I sort of said that I made a little note that there was kind of a thinness, and then I thought that was actually inaccurate, that there was kind of a lack of there was an asystematic kind of character of actually what the tools or instruments that the WTO, right, you describe the effects, right, but not necessarily in a really systematic way, the pathways through which this happens, right? So we have certain things that are identified. We know the rules are out there, and the rules have an effect on the 4 different kind of regulatory phenomena that you identify. There's this process of meeting and justification, so kind of classic kind of constructivist kind of story, right? There's the role of litigation in the DSB, right? And you haven't really kind of in a very systematic way set out, you know, how the WTO regulates, shapes regulatory governance. And the reason why that was kind of interesting to me is I started thinking about, well, geez, how would we tell this story if we're thinking about some other international kind of regulatory systems? The WHO, right? The International Maritime Organization, ICAO, even the ICRC, right? The UN Framework Convention on Climate Change, right? We see some aspects more or less, and so I'm immediately attracted to the idea of kind of comparative analysis and what do we learn from this study, you know, about the likelihood that other organizations, other regulatory frameworks, international frameworks, you know, might have the same kind of effect. So again, it's not really a project to take on in this paper. It's a whole other project, but it seems interesting to kind of, you know, think about it again in a more just systematic way.
Sure, that's great. This makes me think of maybe how there's a page limit, right? A word limit for these sorts of journals, unlike law reviews, right? Where, but clearly, and I would say that there's, you know, 4 core mechanisms, right, through which the WTO operates. One is coercion, right? Second would be reciprocity. Third would be persuasion, deliberation. Fourth would be some sort of emulation or modeling, right? And I think that all 4 operate, right? And I could write a separate paper, sort of the mechanisms, right, or pathways, right, how regulatory governance, and just spin off a paper doing this. But I think it's
there's no shame in doing that.
I think it's in the paper though. In some ways, I could make it more explicit, right? So clearly, the dispute settlement system, in a sense, is based on a form of enforcement, that potential coercion, right? And you can think of coercion in different ways that the WTO provides. So one is, you know, simply if you don't comply, I will retaliate, right? Second is, outside of dispute settlement, it creates leverage, right? Carrots and sticks. So the United States does this all the time. Certain countries can do this, right? Which is, if you don't comply with these particular norms, right, there'll be consequences. And the consequences could include, we won't give you favorable access to our market if you're a developing country, we withdraw technical assistance or foreign aid or so forth. So that's, I think that, you know, the more central mechanism is reciprocity, because you're always forced to just look at, if you're challenging somebody, also looking what yourself are doing, and vice versa. And it's that reciprocal mechanism which I think is central to understanding why countries are pressed to adopt and implement these regulations. I tried to get at persuasion a little bit, that there's deliberation in these committees and so forth. And of modeling, right? Simply emulating, taking, if you want to have access to the US market or the European market for fish, you better create, and you're from Kenya and Uganda, you better adopt whatever requirements they have. And it's a lot easier to simply adopt it wholesale, right, than to start it off from scratch. And so I think one could get at this. In terms of comparative analysis of other IOs, I would love to see that. So I'm not going to do it, at least in this paper, but part of what this paper, maybe the aim to put into the conclusion would be, we should really, this is not simply just for people interested in the WTO, right? This is it for people interested in other organizations, and it gives you a way to investigate in human rights law, in other areas of regulatory law, business law, on how this plays out. And just to make a pitch, there's a book coming out by Cambridge this year that I co-authored with Terry Halliday as a sociologist called Transnational Legal Orders that looks at 12 different domains. And this is including human rights and other areas of regulation. So it is being done. Yeah. Yeah.
Yes. So two questions. First, so for this more kind of normative account of the WTO, which was being explored also by Professor Simon, I think it would be interesting to know a little bit more about like the process of decision making of the institution, right? And I know that the main scope of your paper is to analyze like the impact on domestic legal regimes and institutions, but I guess that even for explanatory purposes, I would say that a lot of the impact could be also functional or conditional to how the system operates and what's the interaction at the level of the decision-making process between the World Trade Organization and the second point is so I'm not very familiar with this, but how do you dialogue in this paper with kind of all this literature of global administrative law? And I think it's related to my first point, because is that like the impact of the WTO is so strong because of the uniqueness of this institution, or because we are in this more broader movement? And I can recall before coming to Stanford, I was working for the government of Chile, and it was just in the process where Chile was trying to enter into the OECD, and Chile enacted so many statutes just because they wanted to be member of this institution that it makes me like we're seeing this in other institutions as well, or it is a part of a broader movement, which makes the case even stronger for what you're analyzing.
Yeah, this would be great. So on both questions, so on the about WTO decision making, my response would be, and I write on this in other areas, but the response is not static. Because of these implications that this paper addresses, you see a lot of pressure on the WTO itself trying to justify itself opening up, becoming more transparent in the dispute settlement process. And you see developing countries, especially the large ones, becoming much more engaged. So Brazil has put huge resources to try to develop legal capacity. India is doing this. China China, in terms of quote the rule of law in China, and the traditional cultural perspectives of China, not losing face and not having confrontation with a formal dispute. China is the most active member in WTO dispute settlement today. Obviously, it started off with the United States and Europe bringing a lot of cases against China, but China realizes that it can't just be on the defensive all the time, and so it's actually becoming engaged in hiring lawyers and so forth for WTO dispute settlement. And so you see this being recursive, right? As the WTO has these sorts of implications, of course it should be contested, right? And that, so that puts pressure on the dispute settlement system, and it puts pressure on decision making. And it's far from equal, as I've written other ways, that law is not, that you can't see law and power as a dichotomy, either or, right? Those who can mobilize the legal resources are going to have huge advantages in a system against those who don't, right? And so, part of the project, which Sergio has worked on and others, is how to either pool resources for developing countries, how to, and they've done so through creating something called an advisory center on WTO law, which is a form of subsidized legal assistance, and you see countries trying to develop this inside on their own. And so that's central, but I would see them recursively. And then how I dialogue with the GAO, and I was part of the first GAO workshop. And so GAO is a normative project, basically, about creating administrative principles to govern or to assess and make more accountable and legitimate international law rulemaking. And so that's again looking at the WTO as opposed to national law, whereas what I focused on is this aspect of what's a recursive process. But clearly the GAO fits into my first point, is sort of a pressure to make the WTO, if it's going to have this type of authority, becoming much more transparent. And it has been. If you look at the why the WTO has incorporated into its committee system observer status for environmental organizations, the World Health Organization, and others, to try to bring in. They, of course, are the nodes for regulators in administrations in countries around the world. And so you try to make it more open to this sort of what are the implications of what takes place here or other areas of law. Yeah.
Come in, I don't have time for it. We'll take one last one.
Yeah.
Sorry, I have two questions, so maybe you can choose which one.
Yeah.
The first is really naive.
What's your name?
Oh, sorry. My name is Hajin.
Hajin.
The first is very naive, but I broadly agree with the thesis that that the WTO can actually increase regulations as opposed to just deregulate.
Mm-hmm.
And I'm curious what your stance is on investor-state arbitration clauses in particular, since that's been a matter of recent debate. And I just forgot the second question, so maybe that was my homework.
Ask it afterwards. But on investor state, I would like to think more about it, but I tell you, I think that the investor state is much more problematic than the WTO. Clearly it provides private rights for one set of private actors against states, and it's unidirectional, unlike what I just said about the WTO. Because the WTO, states can challenge other states and defend themselves. And by being on both sides and having to be both sides, that opens up a contestatory and justificatory space. Right? Whereas traditionally investment law 1 is changing, right? But it used to be that you had investor states and receiving states. And the US was always the investor state, so it always wanted to maximize investor protections. The only reason why I think it's becoming a little bit, it's opening up a little bit, because once the United States actually receives investment and has to justify US investment regulations, at least it creates that other side. But because it's asymmetrical, providing one set of rights outside of national legal systems, it's much more problematic. And I do think, though, because it's been relatively problematic, you see real pushback on the regime, which itself now has to try to justify itself. But it doesn't have the institutional mechanism, since it's all ad hoc arbitrators, with the arbitrators not having a permanent set of judges like in the appellate body who are up for 4-year once renewable terms, but rather, judges who make their careers by being appointed again, and the repeat players are going to be the investors, right, who bring these cases. It's institutionally much more problematic.
Well, I thought that was a great talk, a great comment, and a really thoughtful set of questions and responses, so please join me in thanking everybody who participated, including yourselves in tonight's event.